Assalamualaikum warahmatullahi wabarakatuh and a very good day. I bid to Dr. Ani Munirah binti Muhammad, my lecturer for Law of Evidence 2. My name is Muhammad Ashraf Haikal bin Ashri, my metric number 255762. So today I will be presenting on the principle of character evidence based on the case of Lim Baba versus Public Prosecutor 1962 Volume 1 MLJ page 201. So basically there are three parts in my presentation today, which are the details of the case, which consists of facts and main issues, ground of appeal, and decisions of court. The second part will be the reflections and lessons taken from the case, and last but not least, recommendations and conclusions. So basically, as for the details of the case, the introduction part, which the appeal was presided by Ismail Khan J, meanwhile SM Young and Muhammad Saleh Abbas, Deputy Public Prosecutor, for appellant and respondent respectively. So as for the facts, the appellant was charged and convicted by the Session Court. Appellant was charged and convicted by the Session Court for the offence under Section 366 of Penal Code for abducting a 19-year-old girl for the purpose of illicit sexual intercourse. So basically, what happened in the case was the victim or the complainant, together with all uh, 9 others of her friends, were having a dance in a hotel in Malacca at that time. So after the dance, they all stroll around the street separately according to with their partner respectively. So the victim and her partner um, was taking a stroll in the streets of Malacca, and then while strolling, both of them was assaulted by the appellant and his companion. And then the victim was abducted and was taken into a car drove by the appellant. And in that particular car, the victim was sexually assaulted by the appellant companion. So after a few moments, both of them dumped the victim nearby residential area, which happens to be the nearby to the house of one of the victim friend. So at that time, one of the victim friends was a police officer, and then the victim met in her distress condition, met with her friend, and her friend took her to the police station to lodge a report. And then the appellant was caught by the police at the roadblock nearby. So during the trial, the appellant was convicted for the offence of under Section 366 of Penal Code. The, dissatisfied with the decision of the Session Court, um, there were basically 4 grounds of appeal, but I will only cover one ground of appeal, which is related to the topic of character evidence, which is the trial judge was wrong to disallow any question by appellant counsel as to her character. So at the end of the appeal is allowed as there was error made by the trial judge as the Court of Appeal order for a trial before another judge. So moving on to the part of reflections and lesson learned. Fundamentally, the evidence of character is not permissible as the court will try the tribal issues, not the man himself. However, there are certain exceptions which can be employed. As for the civil case, and the exceptions are stipulated under Section 52 and 55, while Section 53 and 54 applicable for criminal cases. Other relevant provisions are Section 6, 8, 14, and 15 of Evidence Act 1950. So the question is, does character evidence applicable to the witness? As I said in the general rule, normally the character evidence only applicable to the accused, which facing the charge. But in this case, the situation is quite different as the question of character evidence was aimed to the character of the complainant, which are producing the statement before the court. So Generally, the character evidence only applicable to the accused in criminal cases. However, Section 146 of Evidence Act 1950 stated that the witness can be cross-examined upon three purposes, which to determine his or her credibility, veracity, or accuracy in delivering the statement. Second one is to identify who is he and his position in life, and last but not least, to shake his credibility by injuring his character. So we make a reference to one of the Indian case before the Privy Council, Bombay Cotton Manufacturing Company versus Motilal Shivlal ILR 1915, which the court in this case held that is very relevant to question the witness character during the cross examination, as whatever the witness might say in the box can be prejudiced to the accused in the circumstance where the judge opts to believe the witness. And the same stone was delivered in the case in our local case, which is the case Sharma Kumari anak perempuan Om Prakash versus Public Prosecutor 2000 Volume 6 MLJ page 282, which it can be said that Section 146 has widened the exceptions that allow the question of character to be aimed towards the witness. So as for the recommendations and conclusion, in the case where the prosecution heavily relied on the story of the complainant as the main testimony and evidence in a trial, the defense counsel should be given opportunity to question the credibility of the witness through cross-examination in order to ensure no prejudice has been committed against the accused. As for that, I end my presentation today and thank you.